This conference will now be recorded.
Good afternoon, everyone. My name is David Arcilla with Better Business Bureau, Southeast Florida and the Caribbean, and I'd like to welcome you today to our first webinar of the year. Today's topic is going to be on contracts, the do's and don'ts. And today for this presentation, we have a very special guest, one of our board directors here for the Better Business Bureau, Ms. Tania Bartolini. But before we get started, I'd like to kind of give out a couple of just housekeeping rules. Number one, the webinar will be recorded. So please rest assured that if you want to revisit this webinar, we will be sending the link to this once it's completed and recorded. We'll send that over to you guys on via email, sorry. And secondly, we will be taking questions throughout the presentation. So if you have any questions, please drop them in our little chat box, which should be found somewhere on the screen. And Ms. Bartolini will take care of them as she receives them. So without further ado, I will let Ms. Bartolini take the floor, and I will put myself on mute. Tania?
Yes, good afternoon, everybody. Can you hear me?
Yes.
Okay. I hope everyone's doing well today. As David stated, my name is Tania Bartolini. I am a real estate and business attorney located in Fort Lauderdale. Before we start, I want to make sure that everyone understands I am not giving legal advice today. I'm simply going over some of the do's and don'ts of contracts so that you're cognizant of what to look for. Nothing I give you today is meant to be used in lieu of an attorney. That being said, it is very important for every business to have some understanding of contracts, as they're usually a daily part of business. We have contracts with employees, vendors, and customers, so it behooves business owners to at least know what to look for in a contract. And if you have any questions as I'm going through the presentation, please go ahead and write them in the chat, and I'll do my best to get to them and answer them either during or after the presentation, depending on where they may fit. So without further ado, let's jump into the first don't. Do not rely on a handshake. I have to tell you, by far, this really is the biggest mistake businesses make. People, we are inherently trusting, and there's nothing wrong with that. We like to trust people. We like to do business with people. We like to think that everybody's going to do what they say. And for the most part, it's true. And, people do what they say they're going to do. However, when it comes to business, it's better to have it in writing. Now, oral contracts can sometimes be enforced, but there are strict parameters. So if you do not fall into those parameters, your oral contract might not be enforceable at all. For example, oral contracts for the sale of land, the sale of any goods over $500, or anything that's going to take over a year to finalize, those are not enforceable. And those cover the majority of contracts. And even if you fall into the contracts that are enforceable, it is problematic to prove, because now you get into a he said, or he said, she said, and you're relying on a judge to basically tell you who the judge believes or not to make a decision without knowing the intent. The other problem with oral contracts is intent. Sometimes we say what we mean, sometimes we don't. Just because I might think you understood me in one way, it doesn't mean that that's actually what you thought I said. So it makes it much easier and clearer if you have everything in writing and you do not rely on handshakes and oral contracts when you're doing business. Now, do include all parties. You have to remember that your business is its own entity. So even if you're the sole proprietor, you're the sole owner, The business is its own entity. It's a legal entity onto itself. So whenever you're writing contracts or going into contracts, make sure that all of the parties that are included, that are, that have responsibilities or things to do are included in the contract, because otherwise you will not be able to enforce that contract against them if they did not sign it. So you always have to remember who is actually involved and who has to do things and who's responsible for certain things. Entities and people should be included in the contract. This is a big one. Do not use online sample contracts. With today's technology and information so readily available at our fingertips, everybody thinks that they can get everything online. And that might be true for the most part, but when it comes to contracts, it's very, very difficult to find one that actually meets your needs and the criteria of the state that you're in. All of these sample contracts that you find on Google or legal websites, they might not be written for, let's say, Florida. Every state has its own laws and statutes, and every state has its own criteria for what can and cannot be enforceable. So if you get an online contract and you think you're being protected, you might end up in court and understand that you're not. All of the terms that you signed are getting thrown out, or the whole contract is getting thrown out. Another thing, which I've had a client come to me with a contract like this, it can dictate that the lawsuit has to be filed in another state. So even though my client was a Florida business, they did business with another Florida company, everything happened in Florida, their contract said that they have to sue in New York. Well, they really can't sue in New York because New York laws do not allow you to sue in New York if none of the actions were in New York. If the defendant's not in New York, if the plaintiff's not in New York, if nothing is there, you're not going to be able to sue there. So these are things that you have to be cognizant of that, a normal person and a normal business person is not going to know. These are things that only attorneys would be able to help you with. So please make sure, if you do want to look at online sample contracts, look at them from an educational point of view, not from a usable point of view. Do understand the terms of your contract. Now, attorneys go to law school for 3 years to learn a new language, which is called legalese. This is what we use to write contracts with, and if you're not an attorney, it's very hard to decipher what they mean. Now, even contracts that aren't written in legalese, okay, you might need some help understanding what the terms mean. It's very important that you read every word, that you pay attention to the different meanings that these words can have in the context that they're used. You pay attention to grammar and placement of commas, because as we all know, the English language is very fluid and it's amazing, but it's also very confusing, or can be confusing, because depending on where you use a word, it might have a completely different meaning than what you had intended. So whenever you have a contract, don't just sign it. Make sure you read it. Make sure you understand what it means, what it says. If there's anything that could be up for interpretation, what are those different interpretations? What can they mean? And is it something that you're intending for it to mean? Going into this, do not have ambiguous contracts, okay? Just as you need to understand your contract, it's imperative that other people can understand it as well. As Dr. Seuss says, say what you mean and mean what you say. This is universal, whether you're talking to people, conducting business in your personal life, and especially in contract. Don't think that if you make it ambiguous, you can go back later and change your mind and still be within the terms of the contract. People have done things like this, and it usually comes back to bite them. The clearer the contract, the better it is. The better each person understands what they're responsible for, what their duties are, what they're supposed to do, and what they can expect from the other party. This is why, you have to include as many terms as you can in contracts and make them as complete as possible so that your intentions are written down, the other party's intentions are written down, and everybody can be on the same page. You can use contracts, and you should include terms to address any changes that could happen, changes in the market, changes in the relationships, changes in the business. What happens if, who does what if, things like that. You can't put everything in there because we don't know what, everything that could possibly happen. And you'd have a very, very, very large contract if you did that. But as a business person, you know your business. You know the things that can go wrong or that normally go wrong, or things that people get confused about. So make sure you include those in your contracts so that everybody can be clear. Do have a standard contract with your clients. Again, it's all about clarity. It's all about knowing what to expect by all parties and knowing who's responsible for what. When it comes to your clients, most businesses have one or two, maybe three different products that they offer, whether it's a service or an actual product. So you can and you should have a standard contract with your clients for those different products. You may need to have, one contract for each product or service, but at the end of the day, you should try to get those standardized so that you can use them over and over and over again and not have to spend more money every time you have a new client. The contracts that you have with your clients should really spell out what you expect from the client, as well as what the client should expect from you. So things like payment terms. When do they have to pay? Do they have a grace period? If they don't pay, what can you do about it? How are you going to collect your payment? Are you going to stop working? Are you going to go back and repossess the product that you gave them? Do you require payment up front, half when the job is done? All of these things should be spelled out in your contracts with your clients. Another big thing that you should have in your clients is what's called an attorney's fees provision. In Florida, when it comes to contracts, if you have to sue someone or defend a lawsuit, you usually have to pay your own attorney's fees. The caveat is if the contract has a provision in it that allows you to recover your attorney's fees if you have to pay someone or if you have to file a lawsuit. So most of the time I find that, breaches of contracts are not worth filing a lawsuit over because they don't have that attorney's fee provision in it. So people don't want to spend the amount of money that they're owed to get it back. It makes no financial sense. If you have an attorney's fees provision or a collections provision that any on collections you get to add to the amount that's owed to you, it makes it worth it for you to go after those people and after that money because you can recoup everything. It's very expensive to file a lawsuit, and you don't want to be stuck not being able to collect your money because it makes no financial sense to go after that. Okay, so far I don't have a single question, so I guess everything is good right now. Nobody has any questions? Okay. So do not forego an employment contract or an employee handbook. Florida is an at-will state. You do not have to have an employment contract. And most of the time, you don't really need an employment contract. However, every business that has employees should have an employee handbook. Okay, the employee handbook has to address labor laws, anti-harassment laws, medical leave laws, and many other things. In the employee contract as well, you can address what's expected of the employee, how things will be handled, what's expected of the employer, whether or not you're going to give them PTO, when the days off are going to be, things of that nature. You should also put in the employee handbook things such as disciplinary actions. How will the employees be disciplined and for what? When can they be terminated? Usually with, let's say, anti-harassment laws, a lot of businesses have in their employee handbooks, if you were found to have harassed someone or have, especially with sexual harassment, then you are terminated on the spot. If you have that in your handbook, that not only protects you, but it also protects the rest of your employees as well, and it stops people from doing things that they're not supposed to be doing. Sorry, thanks, David. So yes, make sure you have an employee handbook so that you can protect yourself as well. Because if you don't, the other employees can actually sue the business for, other employee actions or even customer and client actions. Now, do provide a non-disclosure agreement or a confidentiality agreement. This is especially important for startups because you have a new idea or a new way of doing things, and you can't wait to share it with the world because it's the best thing since sliced bread. And that's great, and you should go with that. However, you need to have something in place that would prevent other people from sharing or stealing your idea, whether intentionally or not. Many business owners fear that giving a non-disclosure or confidentiality agreement to other people makes them think that you don't trust them and you're going to hurt their feelings or hurt the business. But the opposite is actually true, because if you take your business seriously enough to protect it, then others will take your business just as seriously. Okay. By doing the confidentiality agreements and the non-disclosure agreements, you're showing the world that you're not a fly-by-night business and you're committed to striving and growing. You're showing them that your idea and your business have so much worth that you don't want other people to take it without having to pay for it, without some kind of value back to you. So make sure you have those. They don't have to be extraordinarily expensive. They don't have to be, 5-6 pages long. They could be one paragraph in an employee handbook, for example, that says the information you obtain in the business during business hours, the client lists, etc., are all confidential, and you are not to disseminate them to others or share them with others unless they are work related or something to that effect. As far as vendors and clients, you will usually have to either include that in the vendor contract or give them a separate piece of paper, or include it in the contracts with the customers so that they also understand that this is proprietary information. Okay, going to proprietary information. Do not omit a privacy policy. If you have a website, you should have a privacy policy on it. In your employee handbooks, you should have privacy policies. There are so many different privacy policy laws around the world. And even if there's no specific privacy policy law in your state, you could still be liable under another state's laws or country's laws, because we are so fluid now that business can be conducted throughout the world with the internet, and you can have customers and vendors all over the world. So different laws are going to apply to you. It's not just Florida law because you're based in Florida. So in order to protect yourself, you have to make sure you have a privacy policy. And it's very simple. All it is an agreement that says, we're collecting your personal information, this is how we're going to use it, and this is how we will keep it safe. And every business falls inside this. If you accept credit card payments, you are collecting personal information and you are subject to the privacy laws of other states and countries if people from those countries are using your services or have paid for your services with their credit cards. So to keep yourself out of trouble, make sure you have the privacy policies. Do negotiate contracts. A lot of times we think that we can't negotiate contracts because we want to hire a vendor and they just give us this form contract and tell us to sign it. And it's probably 3-4 pages long in very small print. But the truth of the matter is we can negotiate them. You can negotiate every contract. You need to look for vendors that will negotiate terms with you. Shop around, find all of the different terms and the different people and what they're offering, because you might be able to negotiate much better deals for yourself when you have a comparison with different vendors. This goes for finding a bank to use, your cell phone service, internet service, whatever else you use in your business. You can always negotiate the contracts. If you cannot negotiate the contract, make sure you understand what it is that you're signing as well. Even though it's small print and you think there's nothing I can do about this, you still need to understand what it is that you're signing and what it is that you're getting into, because once you sign it, you are charged with knowing and understanding it, whether or not you read it. Okay. Don't fail to have a written partnership, shareholder, or operating agreement. You don't have to have an operating agreement per statute or Florida law. But as Benjamin Franklin said, if you fail to plan, you are planning to fail. These agreements are just that. They are your plan, okay? The operating agreement is your plan on running the business. How will it operate? Who will operate it? What is needed for its operation? How will that be obtained? You know, most people think that, okay, I'm a solo. I don't have anybody else I have to worry about. I'm just going to do whatever I want when I want. And that's fine. But if you have an operating agreement, even if you draft it yourself in handwritten on a piece of notepad or something, at least you have something there that you can refer back to and say, okay, this is what I wanted to do. This is what I planned. Can I change it? Of course you can change it. You can change it as many times as you want, but you have to have a plan to figure out how you're going to run your business. If it doesn't work the way you planned, you change the plan and you keep correcting it until you find the one that actually works. If you just do it by flying by the seat of your pants, you're not going to know what's working and what's not working. And you're just going to continue to do the same thing over and over and over, and you're never going to get a different result. So if you actually write down and have an operating agreement, then it's going to be much easily achievable to have a successful business, because you can see what it is that you've done, you can see what works, what doesn't work, and you can see how to fix things. As far as partnership and shareholder agreements, those are your plans with your partners and shareholders. Again, this goes back to our human nature of trust and wanting to trust everyone. And there really is nothing wrong with that. And if you want to keep those relationships, then you're better off having them in writing. The partnership and shareholder agreements will delineate everybody's expectations. It will tell everybody what it is that they have to do, who's responsible for what happens if one partner or one shareholder wants to do something else. They outgrow the business, or, God forbid they die. What happens to their shares? What happens, to their part of the business? Who gets it? Those are all things that you put into a partnership and shareholder agreement. You can also put in there, what happens if there's a dispute? Are you going to mediation? Are you going to try to fix everything and resolve it between yourselves? What are the steps that you're going to take to resolve these disputes? If it's in writing in a partnership or shareholder agreement, then it's much easier to resolve these disputes. Everybody knows what to expect. Everybody understands what the process is going to be. Fear of the unknown is the most damaging fear that humans have. And once you have an agreement that's written down, you don't have that fear of the unknown anymore, because you know what's going to happen. You know how it's going to happen, and you know what you need to do. Partnership and shareholder disputes are truly some of the costliest, because people don't put their agreements in writing. Siblings all of a sudden go from a loving family to hate in 0 seconds flat, because of things like this, because of businesses. And everybody says don't go into business with your family or friends. That's not true. You should go into business with your family and friends, because who else is going to watch out for your back better than your family or friends? And in order to keep that relationship, it's best if you write everything out and everybody understands where they're going, what they need to do, and what happens if they want to leave the partnership. So I cannot stress enough how important it is to have those agreements written down. Now, do hire a business attorney, and not just any business attorney. Make sure it's a competent business attorney. A lot of attorneys are well-versed in the law, which is great. When it comes to hiring a business attorney, you want someone who's not only well-versed in the law, but who is also well-versed in business, the day-to-day activities, okay? You want someone who understands the ins and outs of business, because it's very easy for an attorney to tell you, yes, you can win this dispute, or no, you're going to lose this dispute. But what does that mean? How is that going to affect your business? That's where you need someone who is an attorney that is familiar and understands business and what goes into the business. Someone who understands the business plan, the business budget, everything else that has to do with the business, your interactions with your customers and your vendors, because all of that should be taken into account when you're trying to figure out what you need legally to protect your business and or your clients. It's exponentially cheaper to spend money upfront with an attorney to properly draft your contracts and make sure you're protected than it is to resolve disputes after they arise. Lawsuits can cost anywhere from $10,000 to hundreds of thousands of dollars. You know, if you have these contracts in place, then you usually will be able to not have a lawsuit and not have to spend the money on going to court. Because if you have everything spelled out, you can resolve disputes the way you had intended to resolve them from the beginning. And that basically concludes the presentation. Does anybody have any questions, any specific questions regarding contracts or their business or how they go and interact?
It doesn't seem like we do today. I guess they're shy. Anyways, Tanya, I wanted to thank you personally for doing this webinar for us today. Hopefully we'll be able to bring you back to share some more helpful information. We haven't decided on when we are going to do our next webinar, but please stay tuned to your email. We usually send those notices via email. As I mentioned previously, we did record this webinar, so we will be sending that over as soon as possible. So please be on the lookout for that. And Ms. Bartolini has been obviously very amazing today, so much so that she shared her information here on her last slide. So if you have any questions after the presentation that you would like to direct with her, please feel free to give her a call or send her an email, and she'll be very happy to answer them. Other than that, thank you very much for everyone. Thank you very much to everyone for attending today, and please be on the lookout for our next webinar. Have a great afternoon, everyone. Thank you. Oh, actually, hold on. I think we have one question. Oh, yeah. Yes, Amy, I'm sorry. Yes. We'll be sure to send you a copy of the recording. We send these all out to all of our accredited businesses, but yes, you'll definitely receive a copy of this recording once it's been done, once it's completed within the system. Any other questions? All right. Thank you, everyone. Tanya, thank you very much. I appreciate it.
Thank you. Have a great day, everyone.
Take care, guys. Tanya.